Well, good morning, everybody. Thanks for joining us. We're super happy to get to spend some time with you all this morning on all sorts of issues in school law. And you get to hear from 6 attorneys today as we talk through things. So let me introduce everybody, and then we're just going to kick it right off. As we know, we will be doing questions through the Q&A box. So please use the Q&A feature to ask us questions. We're going to go through a couple hours of our segments today, and then we'll have time for open Q&A at the end as well, but we'll try and answer questions as we go. But we've got with us today, David Braun, Ellen Lueking, Anastasia Brunner, Luke Feeney, Christensen, and of course myself, Brandon Wright. So thanks for hanging out, but I'm gonna let David kick things off. So David, take it right away.
Thank you. Good morning, everyone. So as we begin here today, we thought it'd be a good idea and a good time to give everyone a quick update on some new statutes. Obviously, the legislature has been very busy lately. We've noted lots and lots and lots and lots of changes to the law. Fortunately, a lot of these are fairly minor changes to the law, or at least changes to the law that may not have major consequences for you locally or require major changes. But we thought there are some things that you ought to at least be aware of. So let's talk about face law real quick. So face law expands the definition of grooming in criminal law, which permits both in-person and third-party communication to commit the crime. Now, there are a couple of things I want to note about this. First of all, the change in definition was designed, I think, primarily to deal with a fairly ugly case, I think, out of the Chicago area, where a child was groomed, but because the child was groomed in person rather than over the internet, there was some peculiar wording in the statute which made the criminal law inapplicable. So they attempted to clean that up and fix that by broadening the definition of grooming in criminal law to include grooming which may occur in person. Now, there are a couple of things I want to note for everyone. First, the change to grooming, although it broadened the definition, did not change the case law dealing with what constitutes remediable misconduct. So you need to be very careful as you're beginning those investigations that you are, in fact, dealing with good evidence that makes clear what it is that you're attempting to prove. In particular, if you've got a request for sex, an offer for sex, or an attempt to secure sex, that's certainly going to meet the definition. But if you've got sort of the generalized misconduct that we see a lot of times with somebody who's clearly doing what we think of as grooming, but we can't prove anything sexual related, we may have enough that we must report, but we may not have enough at that point to terminate particularly a tenured teacher. So I think it's going to be very important that we recognize, one, the broadened definition of grooming may increase the need to report in a lot of these. It also requires the adoption of an ethics policy, which you'll find in the press materials. But I think that it's going to be critically important that we not jump to the conclusion that it necessarily is grooming under the statute, and we not wait for criminal authorities to act, that we act on our own, and we also temper our expectations about what the outcome is going to be. Let's talk about some TRS changes. So 102.525 is the 6% exemption. You may remember that last year when we started talking about summer school, TRS was notifying school districts that those extracurricular stipends, those additions that occurred over the summer, would be included in gross income. So if somebody worked summer school and hadn't in the past and made more than 6% of their prior year's earnings, that may cause a 6% cap issue. There was a law that was changed to exempt those payments over summer school. That's 102.525, but that is only effective for last year and this coming summer through September 15th, 2022. So any summer school work that was last summer or this summer may be exempt, but not other work. A law that's come to me a whole bunch this year is, I've had a lot of questions about another law that was passed that also exempted out overload work from 6% stipend or cap issues. But you should be aware that expired last year, meaning that's a retroactive fix. It's not going to fix anything going forward. 102.537 extends to the 120-day or 600-hour exemption for retirees through June 30th, 2023. So retirees can work more than 100 days. They can work 120 days at least for the next couple of years. 102.554 does mandate participation in the employer participation in the SSP. Remember, the SSP is designed effectively to replace the present pension system. And while we don't have anybody in our schools that's participated in this yet, the law used to have a gap. It required TRS to create an SSP to replace what amounts to the present pension system for employees going forward. But the problem is that the law also didn't mandate employers to participate in that. It just required TRS to create it. So this is a cleanup bill effectively to mandate your participation. So when you get those resolutions from TRS, I recognize there's a lot of discussion right now. Should we adopt? Should we not adopt? Well, we're going to be mandated to participate in it now as a function of law beginning next year, or beginning next calendar year. So to my mind, at this point, we've got to participate in it, adopt the resolution, and move on. I acknowledge at this point that because we don't have anyone participant, we're not doing anything with the SSP. We're just adopting the program and thus doing what we're required to do as a matter of law. I recognize that at some point there are going to be demands to bargain over this stuff. There aren't yet, and until there are, my view is we adopt it and we move on. Once the demand to bargains come, that's the point at which we'll have to deal with whatever those changes may be. Leave of absence changes. So 275 allows 30 days sick leave to be used at any time following birth or adoption. This is another cleanup bill that cleaned up a law that was passed about 10 years ago. The law about 10 years ago dealt with birth or adoption and said you could use up to 30 days of accumulated sick leave for birth or adoption. But there was a Supreme Court case that held effectively that those 30 days had to be taken contemporaneously with that birth or adoption. In other words, right after it occurred. It couldn't happen after a summer gap. So if somebody had a baby in May, they couldn't take those 30 days the following September. Apparently the legislature didn't like that. They therefore cleaned it up to allow 30 days anytime. So that really does mean anytime. So after birth or adoption, if a break happens, the employee gets to use those 30 days. So be alert to that, because a lot of districts had practices that were different because they interpreted the statute to mean contemporaneously with the birth or adoption, consistent with that Supreme Court case. That's been changed now. They can take that anytime. Your practice won't trump the law. 102.335 lowers the FMLA threshold from 1,250 hours to 1,000 hours. It's still 1,250 in federal law, but in the state now, and the Illinois Department of Labor can enforce this, will enforce this, the threshold is 1,000 hours. 102.321 allows students up to 5 days for unexcused absences for mental health reasons. So be alert to that one, that we don't have the same requirements on that anymore. Union and employment issues. 102.252 evaluation for tenured teachers is now at a minimum of once every 3 years. I'm going to be honest with you. This one troubles me a little bit, because not because I care what the minimum is, but because I see a lot of employers writing agreements that basically say, we'll only do evaluation once every 3 years on tenured teachers. Well, I hate that theoretically. I recognize we may get demands to bargain over this, but at least to my mind, there's never a moment where we're not being evaluated. You all are evaluating me right now. I'm not off cycle. There is no such thing as off cycle. To my mind, we notify everybody that they may be evaluated every single year, regardless. We may evaluate everyone every single year. Evaluation is not just a negative tool. It is also a positive tool. And particularly in a time of coronavirus, given what we've all been through, I think some positive feedback might be a really good idea. I recognize that I'm unique in that that is not exactly how evaluation is viewed or how it practically works. But to my mind, we shouldn't be agreeing to evaluate off cycle. We should only be agreeing that this is what the minimum is required, and we'll certainly do what we need to do. 596 is a permanent replacement, says that permanent replacement of striking employees is now an unfair labor practice. That's not really the scary part of this bill. The unusual part is it says lockout, suspension, or otherwise withholding employment in order to influence the position of such employees or the representatives of such employees in collective bargaining prior to a lawful strike is an unfair labor practice. I think that one creates a little bit of issue because a lot of times when we have work stoppages, we do in fact lock out employees. And so this may have the effect of requiring payment of certain groups of employees. A couple of curricular changes to be aware of. 101-227 requires the teaching of LGBTQ history, and 102-44 requires Asian American history. Neither of these bills concern me in the slightest, and they shouldn't concern you either. We should have up-to-date curricular materials that include some of these things, and we should be teaching them. I don't think these are big changes because my guess is your curricular materials already do teach the history of some Asian American individuals and already do teach the history of some LGBTQ individuals that are important in history. We're not teaching anything in particular about them. I don't think this requires major changes. And if it does, I suppose my question is it time to review our curricular materials and maybe update them some? The last curricular changes I want to make you aware of, 522 requires a comprehensive personal health and safety and comprehensive sexual health education. There's a distinction between K-5 and 612. Look, I don't want us developing our own program locally that is unusual and unique. What I do want us doing is being very careful to make sure that we're looking out for those ISB rules, which are coming August 22, 2022, as a matter of law, and that we're preparing to implement the changes that those may require at this point. I don't know that there's a consequence necessarily for not adopting it, even though it's in effect right now. But I do think that we need to be very careful to make sure that we're paying attention to the rules as they may come. I think I've probably come to the end of my time, so I'm going to turn it over to Ellen Lueking and Anastasia Brunner.
Thanks, David. And again, if you guys have questions, pop them in the Q&A and we'll come back to those as we have time. We've got designated time for Q&A at the end, but now we'll turn things over to Ellen and Anna to talk about some fun with Title IX.
Hey, and we always enjoy that, right? So to begin, we're going to talk a little bit about Title IX and how to successfully handle Title IX complaints. And it's important for you to know what is covered by Title IX, first of all. So under Title IX, we have three main categories of conduct. We have hostile environment, quid pro quo by an employee, and then this large group of sexual assault, domestic violence, dating violence, and stalking. So if the conduct alleged, not what you think will be proven, not what you think the evidence will show, but what is alleged falls into any of these categories, it must go through the Title IX process with a finding of responsibility before any discipline may occur for the respondent. Now, on that last one, sexual assault encompasses a handful of things. So let's talk briefly about that. Those first five are pretty obvious. If those are what is alleged, we know that that goes through Title IX. But something that we want to make you aware of here is this last one, fondling. And OCR has chosen to use the FBI definition, which says the touching of body parts of another person for the purpose of sexual gratification without the consent of the victim, including instances where the victim is incapable of giving consent because of age, remember the age of consent in Illinois is 17, or temporary or permanent mental or physical incapacity. So Anna's going to talk to us a little bit now about what hostile environment sexual harassment is.
Okay, so if we look at the next slide, we have the definition of hostile environment. We've broken it down into like the 6 main parts for you. As you can see from this slide, it's pretty narrow. And as Ellen mentioned, what the concern should be is what is alleged in the complaint. So if this is alleged in the complaint, then you have to investigate it. And so if we look at the next one, we're going to see that it's pretty easy to meet the denial of access to an educational program or activity. Even OCR has said that it's a very low standard to meet. And you can see that from the slide. We've got reasonable person. You don't actually have to have any loss. Total access doesn't have to be denied, and you don't have to have a concrete injury. So what that means is that it's almost a given that if hostile, that it's going to exist if it's alleged in the complaint. But Ellen, didn't Biden say that he was going to change those Title IX regulations?
So he certainly did say that. But as we know, in the past administration, it took nearly the entire 4 years of that term to go through the formal notice and comment process. So under this current administration, to make any changes to those regulations, we can probably expect it's going to take a considerable amount of time, years, for any changes to occur. So in March 2021, President Biden signed an executive order that directed the Secretary of Education to begin this process. In June, we had a week of public comments. The last administration took a year and a half to review those comments before they issued any proposed rules. And I think we can expect a considerable amount of time before any proposed rules are made. So as we continue operating under the current rules, when must a district respond to allegations of sexual harassment?
So you've got to respond when you have what is actual knowledge, which is pretty broad. And it doesn't mean actual knowledge. It can also mean, third-party reports from the parents, from the media, from newspapers, potentially even from social media. And so you have to respond if you have an employee who gets any notice of any of these 3 categories. And so if someone has this actual knowledge, what now? What's going to happen?
So the immediate thing to do is to report to the Title IX coordinator. As soon as you hear any report of sex-based conduct, even if you don't think that this single instance rises to the level of sexual harassment, there may be a pattern that in your one class you don't see because you teach one of their 8 class hours of the day. So as soon as there is any sex-based conduct reported, we make that report to the Title IX coordinator so that they can proceed as appropriate. So the role of the staff member who receives that report is to take the report to the Title IX coordinator, not to do anything else. It is not their job to investigate. We have a person whose role it is to do that. It is not their job to discipline because that could be retaliation, which we're going to talk about a little bit later.
So we also have to recognize that there's a distinction between gender-based discrimination now and sexual harassment. So OCR has issued revised guidance that not all sexual misconduct needs to go through the Title IX sexual harassment process. So if it's gender-based discrimination, it can be addressed through school discipline processes. Now, gender-based discrimination, you're talking about a single inappropriate comment. If during your school's discipline process, you find out that that comment has been made repeatedly or that there's similar comments being made, you're no longer looking at gender-based discrimination and you need to switch to Title IX. So, Ellen, what about some supportive measures? What does that mean?
So supportive measures are measures that you want to implement as soon as you receive a report, even if a formal complaint is not filed, because a complainant can certainly report conduct, but choose not to file a formal complaint and choose not to go through that formal complaint process. But something that we sometimes forget about is that the respondent may also need supportive measures as well. In our experience conducting Title IX investigations, respondents frequently need supportive measures. They're dealing with anxiety and stress and sometimes depression when they're facing some big allegations against them. Anna, I know a couple of weeks ago, you encountered this issue as we were conducting an investigation. Would you mind sharing?
Yeah, so just, briefly, while we were doing the investigation, it was disclosed to me that the respondent was essentially self-medicating due to anxiety and depression and stress related in part to the investigation. And so the Title IX coordinator then needs to be made aware of that, and more supportive measures need to be offered because what was being done was not enough. And so if we look at the next slide, so surprise, surprise, in a presentation by some lawyers, we're telling you to document things. I've only been a lawyer for a very brief period of time, and it's already something that I've written and said multiple times. So your standard, as you probably know, is deliberate indifference for district liability, which means that you're being accused of not doing enough. And so you need to make sure that you're documenting every inaction and action. Inaction being if complainant decides that going through a formal complaint process is not something that complainant wants to do because they're worried about the formal hearing being more traumatic for them, then the district needs to make sure they're documenting that no formal complaint was, or the complainant didn't want to go through with a formal complaint because reason X. So Ellen, what's a district to do if there is a complaint, but it is anonymous?
So if you have a truly anonymous complaint from an anonymous email account or an anonymous letter left, the first thing you're going to do, as Anna said, is to document it. You want to watch for patterns, because if there is a pattern that the district should have recognized, they could be found deliberately indifferent. So documenting is important. If you can figure out who the complainant is, you may be able to provide supportive measures. If you can't, you unfortunately are unable to. If throughout, it later comes up that you figure out who the complainant is, you can make an offering of supportive measures. And then there's that question of, can we conduct an investigation of an anonymous complaint? And possibly, if the respondent is named in that complaint that is truly anonymous, the Title IX investigator could sign a formal complaint under their own signature and conduct an investigation, issue the appropriate formal notice of investigation, and then proceed. But Anna, what should a district do if the complainant isn't anonymous but requests anonymity?
So essentially, if you get a request for anonymity from the complainant, it's not really going to be it's not possible under the current regulations. So the written notice requirement is that the written notice has to be sent to the respondent and the complainant of the allegation, and it has to be signed by the complainant. There's not going to be an exception for anonymity. But Ellen, didn't you just say that the Title IX coordinator could sign the formal complaint?
They can. And if the district would be deliberately indifferent, if they didn't investigate it, then the Title IX coordinator should sign the formal complaint. At that point, the complainant's name will be disclosed for the due process purposes. Due process was incredibly important as in the regulations as they are issued and what we are currently operating under. So if what is alleged is violent sexual assault or teacher on student sexual violence, or any allegation of sexual harassment from a teacher on student, the Title IX coordinator needs to sign a formal complaint under their own signature and likely needs to have a very difficult conversation with that complainant. But if the conduct was student on student and it was not violent, then the district should probably honor the wishes of the student and not proceed to sign the formal complaint on their own. However, we always want to provide those supportive measures. And as we think about retaliation, like we mentioned earlier, there can be no discipline at all until this formal process is completed. There must be a finding of responsibility. If there is no finding of responsibility, there can be no discipline. And something else to think about is that when you're providing supportive measures, they cannot unreasonably burden the respondent. So for example, if the complainant requests to not be in classes with the respondent anymore, it would not be appropriate to remove the respondent only from all of their classes. You should work to alter both schedules. And there may be circumstances if you only have one Calculus 2 class, it may not be possible to remove the student from the class if they need that for graduation or something like that. You may have to look at some alternative options. Maybe one of the students could Zoom into class from a different location.
Okay, so the last piece that we have is that the Title IX coordinator needs to be prepared to have an honest conversation with complainants when they're deciding whether or not to file. As we talked about, I mean, a complainant is potentially not going to want to have their name attached to the complaint. And the Title IX coordinator needs to be pretty clear up front that that's not something that's really an option. They also need to be clear about how long this process can take and what is going to be required for a finding and how the whole process is going to work. And that's something that the Title IX coordinator needs to be able to have the conversation with that complainant over. And I think that that is it for us.
Thank you.
We've got a question here on the Title IX piece that I want to maybe discuss with you guys a little bit before we move on to the next segment, since we've got a minute or two here, which actually we've got a couple different notes here. First question is, if it happens outside of school, student to student, and is sexual, does this go under Title IX? How do we handle that?
I think if it's impacting the school environment, you may have a duty to investigate and to proceed. Just because it didn't happen at school doesn't mean it's not impacting the school environment.
Yeah, I think you want to look for that connection back to the school.
Mhm.
But I think, at some point, you're going to get to that point of, did it happen in connection with an educational program activity of the district? And if the answer is no, then it may not be Title IX, but we may be dealing with it under other theories as well.
Mhm.
Another Title IX question, not specific to the sexual harassment rules. If football boosters pay to remodel the boys' locker room, adding carpet and new lockers, does Title IX require the district to remodel the girls' locker room as well? And I love these questions. One, because I think for most of the last 50 years, we've usually thought about Title IX in the context of athletics only. But I think the answer is plainly yes. One of the things that OCR's made very clear is there is no booster club exception. So if booster clubs are donating money and providing benefits to athletic programs, then that is part of the overall program. And so it doesn't matter who's funding it, but that absolutely would be a Title IX issue when it comes to equal benefits. Two more questions here before we move on to Luke on Title IX. What about when something happens on a more massive scale, like a student taking a bunch of pictures of students, girls at school?
I think that an investigation should certainly occur. That may be a complaint filed by the Title IX coordinator if no one wants to come forward and sign that formal complaint on their own. But if there is this happening and you have actual knowledge of it now, which you do if you're asking this question, then it sounds like this would be an appropriate place for the Title IX coordinator to to begin the process of an investigation.
And then one more, and I know you guys are going to come back here in our second hour and talk about some more Title IX issues, so we can come back with some more of the Title IX questions. But is paid administrative leave during an investigation a disciplinary action? Is that permitted?
It is permitted. It is not a disciplinary action because they are still being paid. If they were unpaid, it would certainly be disciplinary.
Another note here regarding the locker room question, there was a famous baseball lights from Booster Club case from Florida where they had to add lights to the softball field. Yeah, I recall that as well. So, well, we're going to come back with some more Title IX stuff in a little while. So if you guys have more Title IX questions, absolutely pop them in here and we'll come back to those. But in the meantime, Luke, why don't you give us an update of where things are at with all of the COVID litigation going on out there?
All right, good morning. Well, first thing you'll notice with my particular segment of the presentation is this portion is exactly one slide long, and you're looking at it. That is in fact strategic. The reason being that we knew as soon as we tried to outline the status of the pending litigation, it was very likely to change. So a couple of disclaimers before I start the update here. One, as some of you in the audience know very well, we are in the process of representing a number of school districts in pending matters. So any update today is intentionally going to be general and focus on public-facing information. We're not going to get into what would be privileged communications or any strategy going forward, but just try and give you a sense of where the litigation is at and what the likely timing of that is going to be. And in order to understand the present posture of the litigation, I think it's necessary to look back over the past several months to walk through how we got here. So the COVID litigation in Illinois started primarily in the southern part of the state, right about the time school started. The cases began in mid to late August and then ramped up as we hit September and October. The first cases that were filed against school districts were actually not mask cases. The first cases that we dealt with, and I believe those are some of the first cases that named school districts as defendants, were actually close contact exclusion cases. The argument by the plaintiffs in those cases was that the district did not have the authority to exclude students from school as close contacts with COVID positive cases. That very quickly morphed into mask litigation. The argument along mask was very similar to close contact and had the same results. So throughout August and September, school districts largely lost cases at the temporary restraining order stage. What that meant is that the courts in those cases entered a temporary order enjoining or prohibiting the district from excluding certain students from school or prohibiting the district from requiring certain students to wear masks. The initial cases were brought student by student, and this is very similar to the Darren Bailey case that evolved a little over a year ago, where there was an injunction issued, but that injunction was specific to Darren Bailey and was not applied to the population broadly. That is, in fact, how the school cases initially rolled out. And then we had a court that applied that to the student body at large. And then we had a number of cases that were filed as class action cases, meaning the injunctions in those cases would apply to the entire student body. The current scenario is that those cases have now been consolidated. So there were a number of cases pending throughout the state. At that stage, the Attorney General had not entered an appearance in any of those cases. And a number of those cases were dropped or resolved in favor of what we've taken to calling the omnibus case. This was a case filed by Attorney DeVore in Macoupin County that listed over 140 school districts. The present status of that case is that the omnibus case has been combined with a handful of cases that were pending in other parts of the state, and the Supreme Court has assigned those cases to Sangamon County. What that means is that there are a number of cases that are presently before Judge Raylene Grishow and are consolidated. At this point, what that means going forward is a little bit up in the air. There is a status hearing scheduled for next week, which we believe will primarily deal with procedural matters, meaning the court has a number of cases that have been consolidated and has to figure out what timelines apply to each case and what timelines apply to the defendants at large. It strikes us that it is very difficult for the court to manage 100+ different timelines in the individual defendants responding, and there is likely to be some type of mass timeline applied to all parties in the case. So the general status on the COVID litigation is going to be stay tuned. Once the court sets the scheduling, we will know significantly more. The prior cases were all based around temporary restraining orders, and we do generally expect this case to return to a temporary restraining order argument. What that means is that the plaintiffs collectively, this would now be all of the DeVore complainants as well as the plaintiffs in the other cases, would be seeking an injunction against school districts on two grounds. One, that the school district cannot require the wearing of masks, and the other, that the school district cannot exclude students as close contact to COVID-19 unless there is a health department order. And as many of you know, the health departments are unable to keep up with that volume, and schools have been excluding students based on the directives in the executive order. So now that the state has been forced to be a party of the case, the state being the governor, the State Board of Education, and ISB, we expect the state to take the lead in defending the mandates, but school districts still have a very important argument before the court, which is whether the schools have authority outside of the state mandates to require masks or to exclude students. So I'm not going to take up the full 10 minutes here because the summation of the COVID litigation is stay tuned. That also applies on the employment side. There's been a motion filed with the Supreme Court to consolidate a number of employer healthcare right of conscience act cases that are pending throughout the state. We do expect that it's likely that will follow the same path as the school mask cases and ultimately be consolidated in Sangamon County. Those cases involve defendants other than school districts as well. So buckle in and stay tuned.
Hey, Luke, one quick question. At this point in time, I know initially there were several TROs granted early on in the fall. At this point, are there any TROs remaining against school districts related to masks or exclusion?
There are no pending TROs that I'm aware of, unless there's a case out there that somehow did not get consolidated into the matter in Sangamon County. All of those TROs were either vacated by the courts in those cases or were vacated when the cases were voluntarily dismissed so that the plaintiffs could join this mega case that was originally filed in Macoupin County. So currently, there are no TROs regarding masks or close contact.
Very good. Thanks, Luke. So now we're going to turn things over to Christine, who's going to talk to us about a topic that you've all heard come out of our mouths many times over the last couple of years, the Tort Immunity Act. So Christine, it's all yours.
Thank you, Brandon. So like Brandon said, tort immunity is something that's come up quite a bit. You've probably heard me talking to you about it if you've been involved in litigation. It's an argument that we frequently raise. And it's also come up quite a bit with regards to anticipated COVID litigation. So we thought it'd be a good time to just kind of take a 50,000-foot view of what actually is the Tort Immunity Act and, some of the foibles that may come along with it. So I want to start here by talking about the purpose of Tort Immunity Act. This is something that we try and remind the courts of because sometimes courts disfavor this idea of immunity. So when sovereign immunity was abrogated, was removed in 1959, there was very much a concern from the General Assembly that this would leave public entities open to a lot of litigation and the coffers of these public entities would be drained very quickly by tort litigation. There was also a concern from the legislature that, we want people to work at school districts, we want people to work in the government, and are they really going to do that if they feel like they're going to get sued every time they do something wrong? And so their way to resolve this was to enact the Tort Immunity Act, which is a shield, which, as this quote says, hopes to shield public officials from having to answer in damages and money for decisions that in hindsight turn out to be wrong. So the greatest protection extends to those decisions that are seen to have some kind of discretion involved. And so the Tort Immunity Act, it provides some limited immunity to not only public employees, but public entities as well, if certain circumstances are met. And that's an important point. This isn't just a broad shield around the district if they do something wrong. There are certain situations in which it's applicable and which it's not applicable. Another point of clarification here that we sometimes run across in court is that the Tort Immunity Act is a shield. So it doesn't provide any additional duties. It doesn't say that the district has to do this, has to do that. Once a court finds that a duty exists to be reasonable, to report, to do this or that, then the court addresses whether the Tort Immunity Act applies. So there are a number of sections that I kind of have on standby that we may bring up quite a bit in litigation. One of them is section 2-103, which provides immunity against negligent and willful and wanton conduct. So pretty much absolute immunity when an injury is caused by adopting or failing to enforce any law. Now I can already hear you cheering, say, oh my goodness, isn't this the best thing ever? I thought so once too. Unfortunately, courts are very suspicious of 2-103. I just had a hearing maybe 2 weeks ago where I was raising this defense in a motion to dismiss, so very early on in litigation. And the judge looked at me and said, counsel, are you telling me that the district has complete immunity against any law? And I went into the reasons why tort immunity existed and how the district was doing all the right things, and the court still found against us. So this is a perfect example of, the Tort Immunity Act can promise a lot, but judges can be very suspicious against, especially section 2-103. 2-201 is something that we habitually raise, and it is probably one of the more complicated sections of Illinois Tort Immunity Act. It says that a public employee serving in a position involving the determination of policy or the exercise of discretion is not liable for an injury resulting from an act or an omission in determining policy when acting in the exercise of discretion. And section 2-109 extends this to the district. So that's a lot of words that really sometimes doesn't make any sense. So essentially what this means is that when you have an employee that's in some kind of position where they're making tough decisions that aren't black and white, and they are actually engaged in that decision, determining policy, so they're balancing competing motives, and they're acting in discretion, so it's not a black and white decision, then they're granted immunity. A great example here that the courts have applied this to a lot is a case of bullying. So when you're looking at cases of bullying, often this isn't a black and white issue, knowing what to do. You're looking at competing interests, for example, determining policy, that's what a competing interest is. You're looking at the interest of the aggressor, you're looking at the interest of the victims, you're looking at the interests of the teachers and trying to balance discipline within their classrooms. You're having to balance all of those things. And you also have a fair bit of discretion in determining what to do. While almost all districts have a bullying policy, and there are some guidelines, any administrator will tell you that there's quite a bit of discretion that's afforded to them in knowing what to do. So in those situations, section 2-201 is a perfect example of how immunity can be provided to public officials, administrators, and by extension to the school district for those types of decisions. But as you can hear, this is often a very fact-intensive determination. So while section 2-201 may be successful ultimately down the line in litigation, it may not be successful early on. Section 3-106, this comes up sometimes. This is the injury that's based on the existence of public property intended to be used for recreational purposes, for example, like playgrounds. So a few years ago, we had a case where a child fell down from a playground and attempted to sue the school district. This was a perfect section to apply, and immunity was granted to the district because the court found this is the exact type of situation where courts want to grant immunity. We want to encourage school districts to have playgrounds. It's anticipated that, if a child may climb up on a playground, they may fall down. And so immunity is extended in those types of situations. And finally, section 3-108, this is something I assert quite a bit on behalf of school districts. This provides immunity for school districts when there is an injury that is caused by negligent supervision. Now, there's a big caveat here. This does not extend to cases in which willful and wanton supervision is applied. And so once again, it's a pretty narrow window there. COVID-19 is at the front of our minds. You've probably heard us talk about tort immunity quite a bit in regards to COVID-19. These are three specific sections that may apply in the future if there is some tort liability that's raised against the district. Section 2-202, A public employee is not liable for an act or omission in the execution or the enforcement of any law unless the act or omission constitutes willful and wanton conduct. 2-203, if a public employee acts in good faith under the apparent authority of enactment that is unconstitutional, invalid, or inapplicable, that employee is not liable unless they would have been liable if the enactment was constitutional, valid, and applicable. This is kind of coming to our minds quite a bit as there have been some challenges, as Luke described, about the validity of some of the orders related to COVID. So even if those orders were found to be unconstitutional or invalid, the districts could still assert this section claiming that they were acting in good faith. And finally here, this is very specific, is section 6-104. A public entity or public employee is not liable for an injury resulting from a policy decision on competing interest to perform or not perform any act to promote the public health of the community by preventing disease or controlling the communication of disease. If that decision was based on the result of an exercise of discretion vested in the local public entity or the public employee. I will include just a note here. I think the material word here is discretion. If the district or the public entity has been vested discretion. Some of these executive orders have not exercised discretion. They've been mandatory. There hasn't been a maybe you can do this. So we'll see how effective that 6-104 is and how a court may interpret that. Well, love Alexis from Schitt's Creek. So just like she's saying here, I got your back today, girl. And I love this because with tort immunity, there are some days where it really does have your back. It can be very successful. Like, for example, we were talking about the section related to negligent supervision. Courts are very deferential in those cases. Sometimes with 2-202 in bullying cases, courts can just apply it straight off the bat. It can also limit damages because it can take away some of these claims. But unfortunately, it may not always love you. Just like I was saying with section 2-202, which is dependent on whether there was an act of discretion, whether there were competing interests, that may be very fact dependent. And so while we try and get cases dismissed right off the bat with motions to dismiss, I've had a lot of courts turn to me even in hearings saying, this is very fact specific. I'm not saying you can't raise this section later, but now is not the proper time. So we may still have to go through discovery and raise this again later. Also, some judges may disfavor or misunderstand the Tort Immunity Act. I get this quite a bit, especially with that 2-103 related to, immunity for failing to apply any law. Another thing here, just like we can read tort immunity, plaintiffs can also read the Tort Immunity Act, and they may frame complaints to try and hinder its use. So for example, when I talked about section 3-108, which relates to negligent supervision, a lot of plaintiffs no longer claim negligent supervision. They just go straight to willful and wanton supervision, which precludes our ability to raise that section. And also it requires that conditions are met. It's not just something that you can say, I've been deliberately indifferent, but here you go, 2-202 should still apply to me. So it doesn't allow for bad conduct. So some final reminders here, just like Anna was saying earlier, document. It's very hard to prove that you were considering an act and applying discretion if there aren't any details or you don't document what the district did and why. Another thing, and this is coming up a little bit more for me, documenting is really important. Please make sure you keep the documentation. Number two, and I know we've said this ad nauseum in our emails, do not be deliberately indifferent. Immunity is wonderful, but it only goes so far. So please act reasonably. And finally, call us. If you have questions, it's much easier to address things early rather than dealing with a full-blown crisis later.
Yeah, I think, Christine, as you and I have talked through so many of these cases, over the years where, schools are being sued for personal injuries and other related things, I think we've recognized plainly that if the Tort Immunity Act simply existed as it was written and not as it's been interpreted by courts over time, it would give us a lot more protection than the way it's actually been interpreted over time. And there's an awful lot of nuance there.
And that's why that gets back to that Yogi Bear image of just pulling it out. Sometimes it's just a pure crapshoot whether it's going to work with the judge, regardless of whether it should work or not.
Thanks, Christine. There are a couple of questions here back to the COVID piece that I just want to answer real quick before I jump into my segment here on social media. One, are the executive orders being renewed, or do they need to be? The current executive orders have been extended through December 11th, so the end of this week. So I presume this week the governor will issue another executive order for another 30 days, but that'll be up for this week. The other question here, I think, related back, are schools currently allowed to quarantine students? I thought only the health departments could do that, and only for 48 hours. And that's where I think we've got an important distinction here between the word quarantine and the word exclude, right? The executive orders and the Communicable Diseases Code, the regulations of the Department of Public Health, were amended in September to make clear that school exclusion is not quarantine. And that's been certainly a factor in that litigation as well. So health department quarantines, a school excludes. I know sometimes we trip up and use the Q word in schools, but what schools are doing are not quarantining, we are excluding, and the Communicable Diseases Code is pretty clear about that. Now, that code is part of what is being litigated in that omnibus litigation, but currently the Communicable Diseases Code says that exclusion from school is required with close contacts and positive cases and symptomatic students and personnel, and that is not considered a form of quarantine that would require an order. So that's where we're at right now on that. So again, I know you guys have some other great questions in there, and again, we're going to have a whole set time for Q&A at the end, but I want to spend a couple minutes here on social media and the First Amendment. And what I really want to do is, remind you of the BL versus Mahanoy area school district case, the decision of the Supreme Court this summer, and then jump to, we've had several court decisions around the country since the Supreme Court decision this summer interpreting it, and I think we can take a lot from that. Now, if you recall the facts of this case very briefly, this was a student who was displeased about not making the high school varsity cheerleading team, and she took to Snapchat to express her displeasure. And as a result, the school suspended her from the JV team for a year. She sued, claiming that violated her First Amendment rights, and she won at every step, right? Because, frankly, of course, there was nothing here that created that material and substantial disruption under Tinker that would permit the school district to regulate or have any form of discipline for her conduct. And so the Supreme Court, affirmed that decision on its own basis, although they used different reasoning than the Third Circuit had, saying that there are times where it may be appropriate for a school district to regulate or discipline a student for their off-campus electronic communication or social media, but that is not certainly wide open. And so, they really still applied that Tinker material and substantial disruption test, but with some, I think, limits and guardrails they put around it when it is off campus. And so first, I think is important to recognize is that the Supreme Court sort of recognized there are 4 buckets or 4 categories where they think the school might have jurisdiction for off-campus social media conduct because it may have an impact back at school. And those 4 areas are serious or severe bullying and harassment targeting individuals, threats, failure to follow rules about remote learning and online school activities, or cybersecurity issues. And outside of that, they've said there's not really an interest of the school in being able to do that, and that there are certain features of off-campus speech that might diminish the school's ability to regulate that under the First Amendment. One, we're rarely in loco parentis when it's away from school, and that's often the zone of parental, not school control. And that was one of the issues here in the BL case. That courts should be more skeptical of regulating off-campus speech. That's a heavier burden. And so I think this is where we've got an asterisk placed on Tinker to say when it's off campus, we have to show as the school a heavier burden to show why we are intervening. And of course, that part of our obligation as a public entity is to protect unpopular ideas under the First Amendment. And that's where that case played out. And of course, they found that, her snap away from school on non-school time did not impact cheerleading, did not impact school, did not create a material and substantial disruption, and therefore it violated the First Amendment for the school to discipline her, even athletic code discipline, for her free protected speech under the First Amendment. So we've got a handful of decisions since that Supreme Court decision, and I want to share them with you to show how lower courts now are taking that Mahanoy area decision and putting it in place. And the first is the AF versus Ambridge Area School District case. This was a case decided in Pennsylvania earlier this year in August. This also was a Snapchat case. In this case, the student posted a picture of herself with a gun, with some threats, being there for us. And here in this case, the court found that these were distinct from Mahanoy because these were threats of violence. And so because it was a threat of violence, it fell within that exception and was not protected by the First Amendment. Another case that also came out of Pennsylvania, this actually was a case by the Pennsylvania Supreme Court. So using a slightly different standard here because this is a state court instead of a federal court, but this is a student where two students over Snapchat sent photos of a meme making fun of a third student, okay? So the student in this case, JS, and another student, student one, were making fun of student two, right? And they made a meme of student two saying he's going to shoot up the school and made a video about that. And the school expelled JS for violating the school's terrorism and bullying policies. But in this case, the Pennsylvania Supreme Court reversed the expulsion, finding that the speech was not a true threat and did not cause substantial disruption, in part because this was just messages between the two students and that JS never shared it beyond that. Now, the issue here, of course, is that student one then screenshotted and shared them more broadly, but JS did not. And so they found here that was protected speech under the First Amendment and did not meet that threat threshold. Now, here we've got a federal appellate court decision from the First Circuit just in November. So, just a decision here from a few weeks ago, where the First Circuit Court of Appeals, in looking at Mahanoy, said that speech encouraging bullying is not protected by the First Amendment. In this case, a student was recording another student without their consent and circulated among others, took photos in a locker without consent. The student felt excluded at hockey team events, and found there was a Snapchat chat group where people were posting these photos and videos and sharing him and making fun of him. The court here found that this fell within that category of severe or serious bullying targeting an individual, and therefore was not protected by the First Amendment, and that the school could issue discipline for that. And then we've got the Cheadle case from Missouri. So this case involved a 13-year-old student while at home on a Sunday. So again, away from school, posted a video of herself drinking alcohol to a private Snapchat group. Other members commented. The student was later taken to the hospital. The school eventually learned of the incident by word of mouth and screenshots, and she was suspended from athletics, which prevented her from playing volleyball for her 8th grade year. Now, the interesting thing here is the student tried to argue that she was being disciplined for it being on Snapchat, and therefore she can't be disciplined for that because it didn't create the material and substantial disruption, and sort of tried to use the Mahanoy case as an analogy. But the court went through a lengthy analysis here and said that schools have an interest in deterring alcohol consumption among students, that the school was using the message as evidence of the misconduct, not punishing for the messages themselves, and that engaging in this illegal conduct of drinking alcohol was not protected by the First Amendment, and that the school could regulate the student's conduct of drinking alcohol, but not protected speech, and that this was conduct, not speech. And so I think that's an interesting and important distinction made by the court in this case. And then one last case just decided in November, this one out of the Southern District of Texas federal court. Here you've got some kids who are at a Whataburger. Of course, you're in Texas, you're going to hang out at the Whataburger. They engage in an altercation with a rival football team. There are Snapchat videos that are awful and racially tinged, as you see here. Student then issued a public apology, which basically blamed the school. The school said, hey, take it down. He didn't. And the court did some analysis here of the Mahanoy area case and basically decides this on an interesting qualified immunity basis, saying that that because the school's actions here were before the Supreme Court decided Mahanoy, the school couldn't have known that what they were doing violated the First Amendment rights because of the clarity in the law before, and dismissed the First Amendment claim on the qualified immunity grounds, which is a really interesting way to attack that. And I don't know that that would work the same way in the Seventh Circuit as it would in the Fifth Circuit based on that qualified immunity piece. But I think it's really interesting just to see how that case continues to gain traction. And we see a number of those cases being litigated around the country. So interesting world in which we live on the social media front. Well, David, it's your turn again. So I think you're going to talk to us about collective bargaining now. So I'll turn things over to you.
Sounds good. Thank you. By the way, I always enjoy trying to figure out the distinctions in cases that may have been decided in Texas versus how they might come out in the Seventh Circuit. The collective, we're going to talk about collective bargaining briefly. I think that it is fair to say at this point that money is going to be the big issue this year. Now, money's always the big issue, and I have a hard time ever saying that anything other than money is a primary driver issue, maybe a secondary issue, but most of the time money is a primary driver issue. Even when it was evaluations, it was really money. When it was health insurance is tied to money. It's a function of how much money we're getting. Money is always the issue, but the way it's coming at us this year is not necessarily a function of we don't have money like in the past. Now it's a function of we've got money, but it's short-term money. And in the meantime, we've also got inflation. And those two things may be in conflict with the long-term goals of the board. In other words, we've got mismatched short-term and long-term revenue forecasts. In other words, we may have a lot of money right now, but that may be short-term money. And there's also limitations on how we can use that money. I recognize that a lot of districts have been spending a little bit like drunken sailors, spending pretty heavily right now because we've got some of that short-term influx of capital, which, although we can't use that capital for salaries necessarily, unless we're doing makeup work and those kinds of things, we may have a bit that may free up funds for other things, and we can then use that money for salaries, some of those other funds for salaries. But remember that a lot of that money is short term, and a lot of our spending creates long-term compounding issues. So I want to make sure we're paying attention to that. Obviously, we also have staff shortage issues right now that we've got to deal with. And I am seeing this year a big push to fix something that some unions felt was broken, again, in quotes, several years ago with additive versus deductive TRS. So I'm going to talk about that in a couple of minutes. And then we're seeing a lot of stuff on safety this year. I have more safety proposals on my desk right now than I think I've ever had at one time. There was a big push on this maybe 15 years ago, and it seems like we're back in this again, particularly in the midst of COVID. So let's talk briefly about inflation. And by the way, I see a couple of questions in here on collective bargaining issues that I'm going to come back to. So I will get to those before I'm done here with my time just now. So generally speaking, remember the union doesn't return to the table every 1, 3, 5 years to give money back or to give language back. So whatever we've given, they'll continue to get more. So generally speaking, a longer term contract works for the board. We generally want as long a contract as they'll agree to. If they'd agree to a 22-year contract, generally speaking, we take that. And at least it's my view that I would pay big money to get a 100-year contract, because once you pay that money, the money's gone, but you can always recoup it over time. The big thing you lose with language is control. And by the way, money on a salary schedule isn't money, it's language. It's money that compounds over time. So be alert that the way you put money in is not the same as money itself. But where inflation is high, it may be difficult to reach longer term agreements, both for the union and for the board. So for those of us who advise boards, be you an administrator, or for that matter, for those of us who are school attorneys, one of the things that we're seeing a lot of is that boards get a little bit more skittish about longer term agreements, but in particular, unions are going to get skittish about longer term agreements, because if inflation continues to go up, then the money they need to keep up with inflation may continue to go up as well. And remember that longer term agreements then may require more significant incentives, because it's always about what does it cost. There's always a trade-off. So if I'm giving up my opportunity for next time, you have to give me enough money that it is, to my mind, beneficial to take that now rather than wait it out and see what happens later. So it's about figuring out where that balance is. My guess is that the contracts are going to get a lot more expensive for longer term agreements. A lot of the things that we're seeing right now have to do with those shortages and bonuses. So a couple of things on bonuses. Watch out for 6% issues on bonuses, because I've seen a whole bunch of districts this year who are under some of those longer term agreements, or who are going into a bargaining year and want to get ahead of it, who are dealing with dealing with a lot of worker burnout and are attempting to fix that with some bonuses. And while that may be very well intentioned, and frankly, I think it is, be alert that those bonuses are not exempt from 6% issues. One of the questions I got a lot this year was, well, but TRS tells me that a signing bonus is exempt. Well, there are two different sections within that employer guide, and they're confusing because both only the signing bonus one uses the term bonus. Technically, both of them are bonuses. Both of them are 6% cap eligible. They're not exempt. The reason the signing bonus is exempt is because it's paid before employment rather than after employment. So it's important to get clear with TRS what you're doing and whether it's actually exempt. But generally, my position is presume everything is going to be 6% applicable unless there's a specific exemption. And I saw a question here a little bit ago. School nurses worked additional hours due to COVID and now is over 6%, intends to retire. Will TRS allow school nurses to go over the 6% threshold without penalty? Remember that TRS enforces the law. And so unless there's a legal exemption set forth in that law, there is no exemption for any particular payment. And at least at this juncture, I'm not aware of any legal exemption for nurses themselves. Now, the specific type of work, particularly overload from last year, may be exempted. But again, that's one that's last year, it's not this year. And two, remember that it being exempted last year may actually create a larger gap this year if we continue to do that same load. So I think one of the unintended consequences, which was fixed for last year, may be that it reduces the threshold for 6% inflation for this year that we've got to be careful that we're watching. Remember that any incentive you do requires bargaining. I've had a whole bunch of situations where boards come into money and try to give that money to employees, and then the union goes, whoa, 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 what do you mean you're giving the union, the employees money? You can't do that. And the employer goes, no, wait a minute, I was trying to give them money. Why would they say no? Well, they're not saying no. They're saying we wanted to be contacted first. And now that you haven't contacted, that establishes the base, the threshold under which you will not go. And now we're going to bargain up from there. Remember, if you go to the union first, you have a much better shot because I'm offering to give you free money. You can take it or leave it. And then you're not bargaining from a base that may be your cap. And also watch out for discriminatory and vague plans. One of the things I've seen a whole bunch of this year is, hey, look out, we're going to remember with this shortage, we're going to try to incentivize a particular type of employee to come work for us. And therefore, we want to give $1,000 bonus for somebody who happens to be right out of school. Well, there could be a discriminatory impact to that, an ageist impact. And so be careful of how you're structuring those plans. Remember, when we set them up vaguely, the employer gets to decide who gets it and who doesn't. That may also have a discriminatory impact. I see a question in here, is 6% true for IMRF as well? The short answer is yes, but IMRF is a very different animal, because while the rules are similar, they're not the same, because IMRF is self-funded. So your exemptions are going to be a little bit different. So be alert when you're doing a bonus with IMRF that you're paying for it regardless of whether you get charged a 6% penalty. So because of the fact that you are self-funded, you're going to be subject to that regardless. The next one is additive versus deductive rate. Remember that the totality of the amount that you're paying on TRS, the board has agreed to, if the board has agreed to pay it, whether you target the deductive number or the additive number is irrelevant. In other words, whether I show the money as gross like I do with IRS, or whether I show it as net, it doesn't matter. It's just which number I'm targeting for bargaining purposes. If I target the net number, then I have to pay on top gross. And that also means that if TRS goes down, then the employee picks up the benefit. If it goes up, the employer picks up the benefit. But the big thing is that remember that if we target the gross number, then that's the number that we've got to pay regardless. And that is good for budgeting purposes. So generally speaking, gross is a little bit easier to manage, and therefore the deductive number is the easier one to show. Some districts do fix this by showing both to the employees, but be alert that if the employees are wanting it to be at added additive, that's a 10% increase to salaries, 9.8901%, and that additive amount is TRS-able and thus subject to caps. The last issue I want to talk about very briefly is safety. Look out for proposals that require consequences for students. For the next slide. Look out for proposals that require consequences for students for particular behaviors, and look out for conflicts with the IEPs. I've seen a whole bunch that require a school district to pull a kid out of a classroom in certain circumstances, or to take certain actions that may protect the teacher, but may also create a mandatory consequence for a student. Look out for those kinds of proposals, because they may conflict with the student's own due process rights. Committees may be solutions to some of these, but remember, committees tend to fall away over time. So be sure we're agreeing to how long that committee will be there and what status quo will be. I recognize that's big, heady Latin lawyer language, but there's a reason we use it, and it's because there's a very old case that says if you don't explicitly agree to what status quo will be, then status quo continues to be whatever you've agreed to. So if you miss the meeting, that may be a grievance waiting for a time and place to happen. Also avoid prescriptive language that requires you to do specific and particular things. With that, I think my time is up, and so I'm going to turn it back over to Ellen and Anna.
Well, there's so much going on in Title IX. We decided to divide it in two and let our Title IX experts jump back in on it. So I'll turn things back over to you two to think a little bit more about Title IX.
Thank you. So to begin, we just wanted to take a moment to remind you that you may have dual reporting obligations. So if something such as sexual violence against a student by a teacher is alleged, you may need to handle that under Title IX, also report to DCFS. also report to law enforcement. Title IX is not singular. There may be multiple things happening at once. However, sometimes a Title IX investigation may be paused while a criminal investigation or DCFS investigation occurs. So we are going to talk to you for a little bit about what CACs do so that you can understand how those work with your Title IX investigations.
Yeah, so it's sort of this presentation is sort of broken up into 3 different parts. And so this is the first one. And so we're going to talk a little bit about child advocacy centers and what that means. Hopefully we'll answer the 3 questions up on the screen right now. What is the CAC? What do school districts have to turn over? And viewing CAC videos as part of a Title IX investigation. So first, Ellen's going to talk about what a CAC investigation looks like.
Thank you. So a CAC investigation has a multidisciplinary team. So there may be a prosecutor. A CAC investigation occurs in a room that looks similar to the bottom picture. And there is a two-way mirror, and behind that mirror, there may be a prosecutor, a social worker, a therapist, and a bunch of other people who are involved to make sure that during this one questioning, we get all of the information we need from the kiddo. In this questioning, there is a forensically trained interviewer, and they're going to ask developmentally and age-appropriate questions. They are neutral. They may be using anatomical diagrams and dolls. These are recorded, which is super beneficial for schools later on. And most importantly, and something that I'm going to speak for a moment on, is using admissible questioning techniques. I personally view this as the absolute most important part of this. And this is the main reason that we do not want our school administrators to ask any questions about adult on student conduct. We immediately turn that over to the CAC. Because if an administrator began asking leading questions or other inappropriate questions, they could ultimately spoil the entire criminal investigation, which could, more importantly, prevent the conviction of a child sex abuser. And that is certainly not something that any administrator wants to do. So that is the most important part of turning this over to DCFS and the CAC immediately. So Anna, what does a questioning look like?
Okay, so if you were to view an interview done by a CAC, you're going to see these 3 main stages. And it's kind of important to realize that, because when you're viewing an investigation, you might be like, why are they asking so many questions about like what the child's eating at the beginning, like how their day has been? And it's because they're following these stages. And so these are part of like the most commonly followed. And they're evidence-based. You may see something else, something similar, but this is following this pattern is something that's admissible in court. And so that way that can be, the interview can then be used. So Ellen, what does the Illinois school code say about child advocacy centers?
So the school code says that multiple interviews should be avoided, and that makes sense based on what we know about trauma in kids right now. And as trauma research continues to develop, we're going to continue learning more. But right now, we know that we don't want to interview kids multiple times about the same thing because we're going to re-traumatize them. These interviews are recorded, and that is for our benefit. If a kiddo makes a disclosure, we can turn around and we can use that recorded interview in our Title IX process, and we may not even have to interview the kid again and talk to them about it. We may have enough just from using what the CAC can provide to us.
Yeah.
Go ahead.
Sorry. So Ellen sort of talked a little bit about this already, and that's that if the CAC is investigating, then the school district cannot do anything. You cannot interview the alleged victim regarding the alleged sexual abuse until after a forensic interview has been completed by the Child Advocacy Center. And so that's important to note.
So there is a reporting obligation. Law enforcement must notify the school when an agency investigation is complete or has been suspended. It must include information on the outcome. And while I tell you this, that this is a must, that doesn't mean that it always happens. So you may need to be in touch with the relevant agency and make contact early, maintain contact, because it is important that you understand what's happening in their investigation so that you can appropriately conduct your investigation. So Anna, if there is a forensic interview, can the Title IX investigator watch that?
So the answer is yes, the Title IX coordinator can watch that. And this is the statute that says that they can. So it's exempt from FOIA, but it can be viewed by, and the role that Title IX would have is the investigators. And so the important part to note here is that it says you can view, not possess, which means that the investigators are likely going to have to go to the CAC to view the interview there. And so, Ellen, what does the CAC need to do related to this process with the school district?
So they must facilitate communication to the Title IX officer, who's going to be the Title IX coordinator, or the school resource officer, or any personnel who are involved in this investigation. They also must communicate to the school the CIC's protocol regarding the process for viewing it. That usually requires a parent consent form to allow the investigator to view it, and those are generally given pretty freely. If this is something that you are encountering at your district, you should certainly be in touch with your school attorney so that they can lead you through the right steps.
And so now we're on to the second part. And so this is more about like staff involvement in the investigation. And so hopefully we'll hit these 3 points. The first one is we're going to start a little bit about SRO involvement. And so this part is just more of a general reminder to make sure that your MOUs or whatever you're using clearly outline the requirements for the SRO, and that's going to include training. And Ellen's going to speak a little bit more about the SRO training and whether or not they can be involved in the Title IX process. So Title IX staff, as we know, must be properly trained. And here's a shameless plug for Brandon's Title IX on-demand training. Contact him if you need, if you realize now that you need to get someone trained, including your SRO. If you're going to have them involved as an investigator, they need to be Title IX trained, even though they may be trained through their own SRO training. And then any training that is done needs to be posted publicly on the school's website. So another big piece of the Title IX regs is the fact that the decision maker has to be kept separate. And so as you probably know, the Title IX requires a written determination after the investigation is completed. The determination has to be made by a decision maker, and that decision maker cannot be the same person as the Title IX coordinator or investigator. So you cannot use a single investigator or an investigator only model. Related to this, it's really important that the investigator is a neutral investigator. So it's very easy for a student to argue that there's been a violation of due process if you can show that the investigator was not neutral. So think about things like that could later be discoverable in a lawsuit, things like emails, texts, stuff like that, where an investigator could be found to be not neutral.
Or social media posts.
Social media posts. Yeah. So.
Okay, so we want to remind you that you have an obligation to maintain these Title IX records, but you also have an obligation to maintain student records. Don't forget that you have 2 separate obligations and they may not be the same time frame. And just because someone says that you must turn things over doesn't mean that you need to. You should not accept legal advice from someone who is not your school attorney. So here is what the Title IX regulations require. That schools must record and maintain documentation of any Title IX investigation, all findings of guilt, including informal resolutions or appeals. Documentation must include the facts on which the Title IX coordinator based any conclusion that it was not deliberately indifferent to the allegation of sexual harassment. So that includes those times when a complaint is reported, but a formal complaint is not filed. And we must remember that parties may request copies of their records, and that Title IX records must be kept for 7 years. The Illinois student records, you may have obligations beyond that. You may have obligations shorter than that, but if it is Title IX, it must be kept for 7 years at minimum.
Yep, and so it's also important to note that schools have to keep records regarding the school's response to all reports of sexual harassment that the school becomes aware of, even if there's no formal complaint filed at all. still have to have a record of it, still have to keep it for those 7 years. And the school should also be keeping and recording any supportive measures that have been offered and provided to the complainant and the respondent by the school. And that's if you offer it more than once, record each time that it's done. And so I think that is all we have related to Title IX.
Hey, I want to ask you both a question. I know you both have done the full training with the CAC to do forensic child sex abuse investigations. Do you think there's a benefit for a lot of our school administrators listening today to reach out to their local CAC and get some information about that process, particularly given the frequency with which we're dealing with that?
Yeah, it was incredibly insightful to just understand what you're watching, the questions that they're asking and why, their methods of doing things, and just to prevent you from asking a question that you might not even realize was leading. As you're just trying to get very basic details, you'll get an idea of where that line is. The CAC directors are absolutely wonderful. We sat in a room with quite a few from around the state for about a week, learning from them, and they're super friendly people. They would love to be in contact with school administrators and to have collaborative relationships.
Yep.
Awesome. Thanks, guys. We'll come back to our Q&A at the end, but now we're going to turn things back over to Luke to talk to us about some Open Meetings Act issues. And I know we've all been to a difficult board meeting or two this fall. So Luke, what do you have to share with us today?
Well, if you are fortunate enough that you've not had a difficult board meeting in the past several months, count your blessings. What we want to do this morning is walk through a few of the requirements, a few updates from the public access counselor, and then a couple strategies to help you get through some of these meetings that are, quite frankly, not going to be pleasant. And I do want to start with the sort of the overview that at some point, you have to accept that you're going to have to sit through some comment that that is not enjoyable. But that is your requirement under the Open Meetings Act. And we can see here from section 10-6 that at each regular and special meeting, you have to allow time for the public to address the board. School districts actually do have a separate school code requirement, but for the most part, when we're dealing with public comment, we're dealing with the school code. So as we move on, there have been a few public access counselor opinions that I think are worth taking a brief moment to look at. One that has been true for a while, but is an area that we still see districts, I would say inadvertently making a mistake, is that you cannot require a commenter to give their address before speaking. This was a practice that a number of districts did. From a practical standpoint, I think the intent was you want to hear from people within your district. The AG ruled that was not allowable as a requirement. You can still request that people give their address, but you cannot require it. And most districts, I think appropriately, have dropped the practice altogether. Second is requiring a speaker to submit a written request to speak 5 days prior to a meeting was found to be out of bounds. And this makes perfect sense because that would be prior to the district even posting their agenda. And essentially, the district could play some games by requiring folks to register to speak before anyone even knew what was on the agenda. Now, we'll see there's some slight changes to this as we get into remote meetings and COVID. Here we have a case that is from early in the pandemic, in March of 2020. So I should say, I suppose, relatively early. This was in the early stage of virtual meetings, and the PAC, in a non-binding opinion, did say that it was sufficient if commenters could email their comments in, and that could be done up to 2 hours prior to the meeting. Obviously, there has to be some administrative leeway if comments are coming in by email. You can't have those coming in up till the 11th hour. Now, as we've all progressed in electronic meetings, I think districts have taken different approaches to this, even allowing public comment over electronic medium that maybe we didn't do very early in the pandemic. So there is another non-binding opinion on the total time that districts can allot for public comment. So I know I'll confess that I've done this, and I suspect many of you have. When you see the list of public comment, you roll down the list and start counting in blocks of 5 minutes, meaning how much time have we just added to our meeting by public comment. The PAC has said that it is not improper, meaning you can place a cap on the total amount of time that you're going to commit to public comment. Now, I'll be quite honest, this opinion makes me nervous. I think that the fact that it is 60 minutes, it's a full hour, is probably what saved it. So I would be very careful in using this opinion or getting cute with it. So if the district has never had a practice of capping public comment, you have a very contentious issue, and you say, today we're going to cap public comment at 30 minutes, I think you're in for a rough time if the PAC thinks you're using this non-binding opinion to play games. That said, you don't have to allow public comment to go on for hours upon hours and delay you from taking any action. So what happens if someone goes over the time period? How do you handle that? So this is where establishing good practices and consistent practices, I think, will help you avoid this on the whole. Certainly not perfect, but setting time limits and holding to those time limits is the best thing that I think you can do to keep people from exceeding their time limits. One of the practices that a number of our clients do, and a number have been adopting, is to actually use a visible timer, meaning there's a screen in the room that shows a visible timer. Speakers know exactly how much time they have while they're talking. Then, they stop. You could certainly cut the microphone, but you don't have to allow a speaker to monopolize. Our advice is to not allow speakers to cede time to each other. So if 10 speakers sign up to address the board on the same topic, it's not generally good practice to allow all 10 of those to grant their minutes to one person and allow them to talk. I think 5 minutes per person, period. Again, the visible timer helps with that. And the piece that is probably the hardest, and the bulk of our audience here today is administrators, but this is a piece that really applies to board members, is I look at public comment as a one-way street, meaning you're listening to the public. And so my preference is that administrators or the board not interrupt or engage with someone during public comment. And the real reason there is that if we're getting into a back and forth with someone during their 5 minutes, you've opened the door for that person to say, well, wait a minute, you just used 2 of my 5 minutes arguing with me. And so, I think the best practice is give the speaker their time, and the board can always address those comments later during its meeting. The board isn't locked into 5 minutes, but the commenter is. So again, a one-way street. If a board member wants to address issues that are raised in public comment, they can do that during the meeting generally. We have a number of clients that have a standing item on their agenda, which is board member comments. That can come at any point in the meeting. A number of boards do that at the end, and it allows the board members to, one at a time, respond to some of the things that have come up without getting into this time-consuming back and forth with the public. The other thing that the board can do, and I think you have to be selective in doing this, is if you have a member of the public that raises an issue that truly does warrant back and forth by the board and does warrant more time, you can add them to the agenda as a discussion item. Again, I think where you need to be careful with that is if it looks like the board is cherry picking the public commenters that it gives the ability to come onto the agenda, I think you're in for trouble there. So if you play it straight, I think that is the best practice there. So a few other tips, to avoid some troubleshooting is, be honest about the anticipated length of the meeting and schedule appropriately. If you know you're going to have a large number of people showing up to comment on a meeting, consider starting that meeting earlier, consider adjusting your agenda. But I don't think it's a great idea to go into a controversial setting and then act surprised by the number of people who want to address the board. Again, that is their right under the law. So it's not simply the board being nice. You have to do that. If there's going to be a major change to your agenda, I favor announcing that prior to public comment. So if you're coming in, you have 15 people set up to talk about a certain issue, and for whatever reason, the board will no longer be taking action on that. Tell the public that, folks, before we get started, we want to let you know we anticipate amending our agenda. There's going to be no action on XYZ tonight. I think if you're honest with people, that calms things down, and you may have less public comment than you initially thought. A couple other items. One, this is a good standing item, even when we're out of sort of, what I would call the COVID drama period, but have a backup plan for large crowds. If you routinely have people that are there for public comment that are spilling out into the hallway, can't listen to other speakers, I think you're setting yourself up for a challenge. So have a standing plan to, adjourn the meeting and reconvene later in a larger space. That also generally calms folks down. Tight quarters don't generally lead to level-headed commentary. And then when necessary, take breaks. There is nothing wrong with a 5-10 minute water and restroom break. Now, the board certainly needs to be careful that you're not taking a break and caucusing during the break in a way that might violate the Open Meetings Act, but breaks can be both strategic and simply courteous. There are limits to what we can all endure in terms of sitting. So I think it's a perfectly acceptable way to break your meeting up and to break up public comment to keep things calm moving forward. So I can't see the chat box right now. I don't know if we have any questions, but happy to take any on OMA related topics. And hopefully we are through the worst of this and things begin to return to a little bit more of our normal ebb and flow with board meetings.
Thanks, Luke. I don't see any specific questions on this yet. We'll see if any pop up, but appreciate that. I know I've been to many board meetings that have just it's been very different, and I think while we certainly welcome public comment and we want to hear from our communities, sometimes it hasn't been polite and professional, and in some case, in fact, it has been outside the boundaries of what's appropriate. And so I think the more we can do to be prepared for that, the better the meetings are going to go.
I do have one final thought there, Brandon. That's a question we've received from time to time: is how does the board limit the topic of conversation? Meaning, John Citizen comes in and wants to rattle on about something that truly has nothing to do with the school district. Can we tell them to stop? So I think the technical answer there is yes. Yes, boards can limit public comment to matters that are germane to the school district, that have something to do with the school district. I think that's also a little bit of a trap in that sometimes I think it's easier to simply listen to something that may not be relevant for 5 minutes than to argue about it. So it is there as an option, but I think unfortunately you have to have a pretty long leash before you start cutting people off, because the fight is simply not worth it at that point.
I agree. And Luke, I think sometimes where that has occurred is because I think historically maybe districts haven't really enforced the rules they've said about public comment. And I think it's something we're going to have to be very consistent about going forward. All right, well, we're going to turn things back over to Christine for a few minutes to talk about another topic that I don't know that we anticipated a pandemic would spur this amount of litigation and administrative hearings over property tax appeals. But, when the pandemic hit and a lot of property values sunk, we saw a huge increase in those. So I know you've got to spend a lot of time on those things over the past year or so, Christine. So I'll let you jump in and take it over.
Thanks, Brandon. Yeah, this is a growing part of our practice here is property tax appeals. And so I just wanted to go over the next couple of minutes, what to know and what to do when you get that letter in the mail that someone is trying to appeal their property tax value. So just as a basic background here, as we all know, taxpayers may appeal alleged overassessments to the local board of review. So they may get their tax bill in the mail, look at it and go, oh my goodness, my property is not worth this, or I don't want to pay this amount. They are able to appeal that assessment to the local board of review. Each county has one. And in appeals that involve an assessment change request of over $100,000 or more, the local board of review is obligated to notify the taxing bodies, which include the school districts in the area. And once you receive the notification letter from the board of review that a property is seeking an assessment change, then the district has a decision about whether or not it wants to intervene in the appeal. So what does it mean to intervene in the appeal? At the local board of review level, the intervention is pretty limited. What it means to intervene is that you can participate in the hearing, and you also have the opportunity to present evidence and information to the local board of review. Now, unfortunately, the time to intervene is tight. Often when I see these notification level letters from the local board of review, they say that the school district has between 7 to 10 days to notify the local board of review that they want to intervene. And from there, they will be given further notification from the board of review when the hearing will be. Now, unfortunately, that notification time is not usually sufficient to obtain an independent appraisal. And so the district's role at the local board of review is pretty limited, even if it wants to intervene. I don't know if anyone's had the opportunity to participate in one of these hearings before the board of review, but what they look like, generally speaking, is you kind of go downstairs into the basement of the courthouse, and the taxpayer presents some evidence. Usually it's an appraisal, an independent appraisal saying that my values are too high. Here's why the county's assessment is wrong and why this should be lowered. And the board of review may ask some questions, and then it can turn to the district and say, is there anything you want us to know? And since there isn't time to submit an appraisal, usually the comments are pretty limited to talk about the impact that a change would make upon district operations. So at that point, once the board of review considers the evidence, it has some options. It can make a change to the assessment, or it can uphold the assessment. Often I see that board of reviews tend to uphold assessments, but this year I was actually surprised to learn that there were a number of boards of review that did make changes to assessments, maybe not quite as dramatic as the company was hoping for, but there were some changes. So let's say that the board of review does not make the changes that the taxpayer is hoping for. What is the next step? The taxpayer can file an appeal to the property tax appeal board. Alternatively, the district can also file an appeal if they feel like the board of review's changes are inappropriate. Now, this is another very, very tight timeline. The petition must be filed within 30 days of the postmark date of the written notice of the board of review. I want to draw your attention here to the word postmark. Please, please, please make sure to keep your envelopes for the decision letters, because sometimes when we receive the decision letters from the board of review, they don't always have dates on them. And so if you can keep the envelope so that we can know what kind of timeline we're looking at, that would be very, very helpful. Now, let's say that a company is appealing the decision of the board of review, and they are still requesting an assessment change of more than $100,000. Then the local board of review, not the property tax appeal board, but the local board of review must provide notice to the taxing bodies. Now, I would love to tell you that the local board of review is very prompt and that they give you very, very quick notice. They generally do not. And so sometimes we receive notice letters months after a taxpayer has filed an appeal with a property tax appeal board. But that being said, regardless of the delay, once you receive notice from the local board of review that there has been an appeal, then the taxing bodies have 60 days within the postmark date to intervene. So to intervene or not to intervene, that is the question. These are very individualized decisions. And unfortunately, because you have 60 days, that they can be pretty involved decisions and they have to be made pretty quickly. So some of the things that I recommend considering and determining whether or not you're going to intervene at the Property Tax Appeal Board, it is a more formalized commitment. You're going to be utilizing a lot more attorney's fees. You're going to, we'd recommend likely getting an appraisal. Those are very costly. And so you're going to want to be looking, just quite frankly, dollars and cents of what will the tax impact be if this request is made. If this is just a few $1,000s, it may not be worth the district's intervention because they have to pay money for the appraisal, they have to pay for the attorney's fees. And so you're really trying to look at dollars and cents wise, does this make sense? You're also going to want to be looking at the likelihood of success. And honestly, sometimes the districts know more about that than we do. I mean, for example, a few months ago, we had a case where the districts were able to share information on the ground about, you know, this is actually an empty building or they're thinking of selling. That's really going to impact the value of this building. And so because we had that additional information, we could consider, you know, this may not be the best idea to participate and to throw money at this situation. Now, I mentioned that appraisals are costly. So usually when we are looking to hire an appraiser, that runs somewhere around $7,000. It could be more, it could be less, depending on the specific nature of the property in question. Another thing here to take into consideration is those appraisals generally take between 30 to 60 days. And I heard me say earlier, you know, we have 60 days to decide to intervene. You can request an extension and those are given. So that gives you some additional time, but this isn't a quick process, long and short. Now you may be looking at this dollar price tag and saying, you know what, this is too much. You know, how about we form a coalition of, you know, a few school districts join together and we split the cost of the appraisal. That can work really, really well. I will say one of the things to be aware of there is that if the district decides to adopt the evidence of another party, then that adopting party is not allowed to withhold its authorization for the settlement of an appeal if an agreement's reached. So let's say you're a school district and you say, you know what, that library or that other school district, they have a really good appraisal. We want to adopt the evidence. That's fine, you can do that. The only thing to be aware of is that, you know, if the property and the board of review and the district who, you know, purchased the appraisal come to an agreement about a settlement, you can't step in and say, no, this isn't fair. We want more. So that's something to be aware of as far as whether or not you're considering the cost of an appraisal. Now, just like I said, settlement is common in property tax appeals. The settlement can be reached between the taxpayer, the intervener, and the local board of review. In my experience, generally when a district is involved, the two main players here are the taxpayer and the intervener or the school district. The local board of review really wants those two parties to take the lead there. As far as a settlement is concerned, one of the things that can be very advantageous is that those can be multi-year agreements, and that provides stability for all parties involved. Now, as far as the tax appeal board, if a settlement is not reached, a hearing can be requested, at which point this really does become a battle of the experts. So you're looking at, the board is going to be looking at whether they think that the taxpayer's appraiser is more credible than the district's appraiser. Now, what happens if, you know, the property tax appeal board lowers the assessment based on the evidence of the taxpayer? In that case, then a copy of the decision is sent to the county treasurer, and by law, the treasurer is required to refund the overpaid taxes. And so that is something to consider in terms of whether intervention is appropriate. Is, you know, if they do win, that money will come out.
Thanks, Christine. I know we've seen such an increase in those property tax appeals because property values changed, or at least in the minds of many people they did. And of course, you know, the impact on local property taxes is very important. So thanks. All right. I'm going to give you a few minutes of special ed and then we'll move into our Q&A. So one, let's think special ed, but two, get those questions coming in. We've got a handful here already from throughout our time together on a variety of issues that we're going to get through, but let's talk about special ed and then we'll move into our Q&A time. There's so many things going on out there right now in terms of what's important with special ed. I had a hard time limiting myself to a few minutes here to talk about things. So I'm going to really walk through some of the key bills that are out there that I think also are going to give me the chance to talk through issues that are related to that. First of those is Public Act 102-339, which is the restraint and timeout law, signed and effective in August. For the most part, it brings what were in the then permanent rules on restraint and timeout into the school code, requires ISB to establish goals for the systemic reduction of restraint and timeout, and it adds an additional meeting requirement related to that. I think a couple things just of note on that restraint and timeout piece. The proposed ISB regulations implementing these changes in the statute are now out. And so that I know through the Council of School Attorneys, we've submitted comments on that. And so for the most part, they just track the statute. So we'll see if anything else comes out in the final version of those rules. Also, ISB did just within the past couple of weeks release its initial statewide goals for this year, which includes a 25% reduction in the use of timeout and restraint by June of 2022 for those students who had 5 or more instances. It also had a goal for increasing the training requirements. So those training requirements are already pretty robust. So those things are there as well. And of course, each district is going to have to create its own local plan in that regard as well. And that's going to come when those regulations are final here over the next couple months. So pay attention to additional things we're going to have to do this school year as it relates to creating those local timeout and restraint oversight teams and the role that they're going to have to play going forward under those new rules under the statute. So we continue to have things happening with restraint and timeout. Also recognize that House Bill 40, now Public Act 102-172, extended the eligibility for FAPE. Under the federal IDEA and historically under Illinois law and regulations, a student had a right to FAPE from their 3rd birthday till their 22nd birthday or the day before their 22nd birthday, unless they graduated with a regular high school diploma earlier than that. In Illinois, we've now extended that beyond a student's 22nd birthday to the end of the regular school year in which the student turns 22. So for a student, if their 22nd birthday is today, then they now have a right to their IEP services and to FAPE through the end of this regular school year. And this is true now going on forever and forward. That's pretty easy to calculate and figure out. I think it has some practical issues. The feds have told Illinois very plainly that because that goes beyond the IDEA, we can't use federal IDEA funds to serve those students after their 22nd birthday through the rest of that year. And so that certainly impacts what local sources of funds we're going to have to dedicate for these students. Also, if they're in a residential placement, because an Illinois room and board is through IDEA funds, there's no room and board reimbursement. So those are very costly things here for the district. And so I think we need to be actively looking, maybe even at legislative fixes to say, if we're going to have to keep serving these kids, we need to make sure that the funding is in place from the state for those students as well. So recognize that is there for us. There was also a COVID-related extension for certain students if their in-person services were suspended for 3 months or more. Hopefully, any students who are in that category, we've already given the notice, we're already serving them. That should be going forward as well. There's also this statute, which frustrates me because it's just evidence of the state being out of touch with what's going on. Public Act 102-254 requires us, prior to placing a student in an out-of-state residential facility, to first try to have located a facility within the state and to do so annually. The reality right now is that we're in a residential placement crisis. There are a significant number of students in Illinois who there is no dispute between the school and the parent that the child requires residential placement, but there are no residential placements available for them anywhere. No ISB approved placement. Under the current rules, a school district can only place in an ISB approved facility. And ISB has put in place some pretty restrictive rules in terms of what placements might be approved. Some of those are financial, and that other placements in other states don't want to be ISB approved because of what that means financially in terms of the amount of funding they will receive per student. There are limits there with the restraint and timeout rules and other factors that are in place that have made our rules about what's an approved placement if it's out of state certainly more restrictive than others, and have limited the number of beds that are available in these facilities for these very hard to serve children. The other thing that's there as well is a lot of these facilities, like you all are experiencing staff issues and staff difficulties as well. So I think those are factors for us to keep in mind. Out there. There have now been some hearing officer decisions, I think litigation pending on these issues. It's a real problem. And the fact that this statute exists just tells me how out of touch folks are with what's actually happening on the ground when it comes to residential placement. And my big concern is we've seen at least one hearing officer decision already in the state where the hearing officer ordered the school to pay the cost of an unapproved placement, which means no reimbursement. And you're talking about placements that are $600,000 a year in that case, without any reimbursement for one student. That would be catastrophic to so many of you in your districts, if not all of you, if that were to happen. And so we want to make sure that we are working collectively to try and come up with a legislative fix to this, because I think it's unlikely that ISB is going to fix that problem on its own. Related to that, there's currently pending, a commission to try and study these high-cost special education students in a way that's supposed to be aligned to the principles of evidence-based funding. We'll see if anything comes out of that. I think more on this student services side with transition services, House Bill 3950 now enacted makes significant changes for transition skills, and so make sure that we are actively looking at all of those changes related to who we have to invite to the IEP meeting, what the definition of independent living skills are, the changes to our dual credit courses. We all have to update our agreements with community colleges by next August. To account for specific requirements now in this statute related to students with disabilities' ability to participate in dual credit, and the requirements whether those courses are on campus or at the community college. So we're going to pay close attention to some of those changes as well. And then one other thing here I would mention before we get to our Q&A are the new qualified interpreter requirements. And frankly, I think this has always been a requirement under the IDEA, but now we've got it specifically in there that there are some very specific requirements for training for folks to be qualified interpreters at IEP meetings. That training is in the process of creating still, even though it's been in effect now for almost a year. But ultimately, we have to make sure that for parents who don't speak English, we're required to make a qualified interpreter available at IEP meetings, and that's going to be very specifically defined. So, that's something we can certainly talk about further as we move through all of these. But I think those are some of the key pictures that are out there on special ed. I've gotten several questions here on special ed. So I'm going to kick off our Q&A with answering some of these special ed questions. And of course, if any of the rest of you on my esteemed panel want to join me in doing so, feel free to do that. But I'll start with a couple of these special ed questions, and then we'll work back into some of these other COVID and IMRF and other questions that are out there for us. But I'll start with the last one here and then go back to the beginning. What if a parent wants to request to record an IEP meeting? Is that permissible? Well, it's permissible, but it's not required. The IDEA is pretty clear that a parent doesn't have the right to record an IEP meeting. The only exception to that is if it's a necessary accommodation to the parent's own disability. But other than that, there is not a right to record under the IDEA. That's been clear in hearing officer decisions, court decisions, and specific guidance from the Department of Education. So I'm typically a no on recording because it tends to stifle rather than promote good discussion. It's permitted, we could do it if all parties agree and consent to the recording of the meeting, but ultimately we are not required to permit a parent to record an IEP meeting.
And Brandon, if I can add something here that's
Please.
tangentially related. Usually when parents want meetings recorded, I think one of the ways that you can address that also is to say, we'll make sure that we document what has happened here in the additional notes. And so I think it's really important to make those additional notes as detailed as you can, not just for the parent, but also for the district as well. I know, at least on my side of things, sometimes when we see due process complaint notices and I ask for IEPs, sometimes those additional note pages can be pretty thin on the ground. So this may just be a selfish plug for me to say, please provide whatever details you can in that additional notes page.
Another question here. Many of our deaf or hard of hearing teachers like to put consult minutes on the IEP. Sometimes I say it's consultation with the classroom teacher. Other times it's for checking in with the student. Is this a good idea? I'm assuming the student would need a goal to go with the consult minutes, correct? Well, typically if we're adding that as a related service, then that is a way to do it. I think one of the things here is we've got to look at FAPE, right? So does that student really need time with that teacher? And my other question is, what's their other special ed minutes? So if those are the only special ed services on the IEP, then I'm concerned that that's not actually specially designed instruction. So I think it's certainly possible to have those types of consult minutes and that they either would have their own goal or be attached to another goal in that situation. But I guess my question would say the extent to which that's appropriate is going to depend upon what else is in the IEP. Does the district have an obligation to provide clinical audiology evaluations? If a student fails at school hearing screening, the parent's given written referral to take them to a doctor but doesn't comply, or the parent believes that it has an auditory processing disorder and desires an evaluation completed by a clinical audiologist with physician referral. I mean, ultimately the answer is if that's necessary for FAPE, then yes. Those could be evaluations that we are required to provide. That's ultimately the decision of the domain team, whether or not that evaluation is necessary. And if the parent disagrees, then they can request an independent evaluation or file due process over that decision. But there are absolutely times where those would be the types of evaluations that would be required. We've got a couple 10-day MDR questions. So let me answer those and then I'll open up broad to some of the non-special ed questions. If a student's suspended and the parent decides to homeschool and the school district dropped the suspension dates, do those dates still count towards the 10 days to have an MDR and to complete an MDR? I think if they homeschool and they're no longer enrolled, and those suspension days were never served, so that's not there. I think the question would be if we're not intending to enforce that suspension, if they were to re-enroll, then I don't think we would be required to hold an MDR at that point. Any of you guys disagree with that or have other thoughts, in that situation? I think, the reality to that is sometimes parents do that to try to avoid the suspension, but, we can certainly come back to that if necessary when that time comes. Another question here, what steps should a district take when a student has almost reached the 10-day suspension and a parent refuses consent to an FBA to develop a BIP to address those behaviors? Well, I think a couple things. When a parent refuses the FBA, I might still try and write a BIP without it, right? I mean, typically we want that FBA because it's really, really hard to write a good BIP without the FBA. But if the parent's refusing consent to the FBA, that doesn't prevent us from writing a BIP. It just might not be as good of a BIP as it would have been had we been able to do the FBA. So my first thought is I would still try and put in place a behavior intervention plan over that. I mean, you have the option to file due process against the parent to compel consent to the FBA, but I think that would be an extreme decision I would make and not enter into lightly at that point. I think I would try and develop a BIP without the FBA at that point, knowing that's certainly not best practice, that limits our BIP.
I'd also add, Brandon, too, just making sure that that process has been adequately documented, and even sending a stands ready letter saying we recognize, well, we've received your notice that you refuse to consent to the FBA. We stand ready to do so upon your consent. That way there's not any dispute later of, oh, I wanted this, and then there's questions about the adequacy of the district's actions.
Absolutely. All right, David, I'm going to throw this question to you. More of an IMRF question. In the race to meet the minimum wage, along with the race to keep up with McDonald's, it's setting us up for serious IMRF penalties. Do you have any suggestions for that? And you're muted right now, so there you go.
No, I'm not muted. It's got to happen at least once every meeting, right? I'm the guy this time. Yes and no is the answer. There aren't great magic bullet solutions, but I'd point out a couple of things just to remember. First, the minimum wage requirement only applies, first of all, it applies to everyone, but most of your longer term employees are not affected unless you've got a practice or schedule which requires them to be affected. In other words, there's no reason that in bargaining with our collective bargaining agent, we can't inflate the bottom without touching the top. Now, I recognize that as a practical matter, that's very difficult to sell, but I've had some districts that have been able to sell that with time. Meaning I had one district that had a really good solution, I thought, which was, for now, the first, they did actually have a schedule. The first 5 cells of the schedule were all getting $1 increases for the first few years to get everybody up, while everybody else got about 25 cents. However, in the back end of the agreements, it was a 5-year agreement. For the first 2 years, it took $1 to get everybody up. But at the back end, those people who just gotten dollar raises are now being increased by 25 cents, while the remainder now goes up by $1 to try to balance that out. I thought that was a pretty good solution. I've had other solutions where employers had folks who were in that retirement window and they're agreeing to what amount to post-retirement bonuses that wouldn't be creditable. That's another solution, particularly for those in-window folks. But remember that IMRF is a self-funded fund. So when we say penalty, it's not the same as we're talking about with TRS. So with TRS, it truly is a penalty. We're paying money to them so that they can pay the employee down the road and for the remainder of their career. But with IMRF, we have always been funding that fund ourselves. It's our fund. That means that if we were overpaying before, we were just paying that out over 15 years, and now we're paying it out over 90 days. So we're just seeing that money a little bit faster. But I discourage you from thinking about it like a penalty and more to think about it like, how am I going to budget for this over time? Because I am going to have to pay that money out. And so one of the things that you should be looking at when you're paying those monies is, how does your budget handle that over time? Instead of thinking about it as a penalty, I can't go over this cap. Think about it in terms of, can I afford whatever amount of money that I have to fund into my fund? And then if not, look for solutions with your collective bargaining agent that both of you can agree to.
All right, I'm going to ask a Title IX question here. So Ellen and Anna, I'll let you weigh in on this. If a complainant and respondent both review the final report and agree to it in writing, do we have to wait the full 10-day review period before proceeding to the next step? And if both complainant and respondent both say they don't need the question and answer period in writing, do we have to wait the full, the question says 5, but it would be a 10-day period before a final decision?
So my answer would be the regulations state at least 10 days. And even if they agree to it, I don't think I would go around that. I would still wait the 10 days. They could still continue reviewing it and find something that they're not okay with at day 8, even though they've agreed to it at day 2. So I would say, no, do not begin the next step, wait the full 10 days.
Here we've got a staff COVID question. If a staff member has an autoimmune disease, is it an appropriate accommodation to allow them to teach remotely when there is a high amount of COVID cases?
Possibly. Remember, reasonable accommodations are a function of the facts, and reasonable accommodations must be individualized and must occur after interactive communication between the parties. You're going to sit down and have the discussion. The fact that an employee wants a reasonable accommodation of remote teaching does not make that mandatorily so. It may be, for instance, appropriate with one teacher and totally inappropriate for another teacher. I could see a situation where we already have 2 teachers in the classroom, and there's no reason from a supervisional standpoint that teacher can't conduct some of the lessons remotely, while we have another teacher who has to be in the classroom, and we have another teacher still who that accommodation won't work. My perfect example, and it's one I had several times last year, was the shop teacher. I don't really want somebody teaching shop with hacksaws coming down on hands completely remotely. I'm sorry you teach shop, but the reality is you can't do that job remotely. It's going to be a function of the facts, and it's going to be individualized. You're not required to offer that just because the employee asks for it. Doesn't mean you're required to offer it. It does mean that you have to have an interactive communication to determine whether that produces an undue burden for the school district, or if not an undue burden for the school district, if it's a reasonable accommodation in light of the individual circumstances you're seeing.
A quick question here, back to my earlier question about the audiologist. Does an audiological evaluation always require a domain meeting? Well, it's an evaluation that requires consent. So typically that would be done through that process. So I would think generally, yes, we're sitting down and deciding, is that an area of evaluation? And particularly the way that question was asked, where we're maybe disputing whether that's really necessary, clearly where that decision would be made would be in a domain meeting would be the right place to make that decision. Few special ed questions here that we still need to walk through and think through. We have a teacher who disagrees with eligibility findings. She's requested a copy of the protocol sheets. Is this something we are permitted to share with her? She also wants a rubric for what assessment asks, so she can see what to look for in eligibility. I'm not sure how to respond to this request. I'll start on that question, and then anybody else can weigh in. I think we've got a little bit of a role of the IEP team and then student records question. In terms of student records, a teacher is entitled to student records when they've got a current demonstrable educational interest and in furtherance of that interest for the student. So assuming this is a teacher of the child who is a member of the team, then I think that teacher would be entitled to the same information that the team had when it considered eligibility. So I think in terms of broadly, the protocols themselves generally are not student records that are shared with the whole team. It's the evaluation reports, but any of that data that was there as part of the team, everybody on the team needs to have access to that information because they were all part of the team. So I'm presuming here by the questions, probably the gen ed teacher who is a member of the team who doesn't like that the student wasn't found eligible because they may be harder for that teacher to serve. That's just the way I'm probably predicting what's going on there. So I think on the front end, and I think that's something that I've certainly seen, and I think this gives me a chance to talk about this, we're required to give those drafts of all written material that are going to be considered by the team to the parent 3 school days ahead of time, prior to the meeting. I think in order to be fully informed members of the team, it's helpful that not just the parent gets that, but everybody else. Because there were times when I'm going to a meeting and I didn't see things ahead of time. That would have been nice for the gen ed teacher to see those things ahead of time of what's going to be in the draft. So I think the protocol, no, but the data as part of the team, that teacher of the child probably is aware of it. The other piece to it here, the rubric for what the assessment asks for. I mean, ultimately the assessment is a district, that's not a student record. I mean, they're an employee of the district. I don't know that they would not be entitled to that. Anybody disagree with that? I think the other thing that I just want to also point out is I have seen so many situations where people are not giving parents the materials 3 school days ahead of time. It is happening everywhere all the time. Nobody's doing it. It's a total procedural violation. You will lose every case. Tell your teachers there is no flexibility. You must provide drafts of all written material that will be considered by the IEP team or eligibility team 3 school days before the meeting. There's no flexibility about it. Do it, because people aren't, and it is creating problems when there's a dispute. So do it.
Yeah, and Brandon, I've seen a whole bunch of collective bargaining language on teachers' rights with regard to IEPs and student records. And I just want to emphasize something Brandon said a couple of minutes ago, which is that the teacher has a right when they have a demonstrable interest in the student's education as a function of the records. And one of the things that I'm seeing a whole bunch of is requirements that teachers have access to all student IEPs. I saw that proposal in one place. I've got another proposal that a teacher have access to all student records. And while they have the right to those records insofar as they have an interest in that child, that exemption within the School Student Records Act is to the extent they have an interest in that child, not necessarily to all records, period. So be careful, because if we're agreeing to that language thinking, hey, it's okay, there are teachers, and I'm getting them a lot of times in the abstract and we're thinking about it. And I've had a lot of situations where somebody came to me and said, I think this one's okay. And I've got to throw on the brakes and go, whoa, 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 because this is worded a lot more generally than I think you mean it, because I don't think you mean it that they get access to any record of Timmy's who isn't in her class at all. I think you need to be very, very careful with that.
And there's been some very specific findings and decisions on that when it comes to, especially like even electronic access to records beyond those students who they have a current interest in. And there's case law to suggest that if it's the purpose is not in the student's interest, but the employee's interest or the union's interest, that the Student Records Act prevents disclosure and that we can't share. And that's been true both in federal decisions and decisions under the Illinois School Student Records Act.
Yeah, there was a really good case out of Chicago a few years ago that even dealt with a tenured teacher who was being dismissed. And the court said, no, you don't have right to those records. If you want those records, even from a due process standpoint, the teacher said, from a due process standpoint, I have to get those records. And the labor board said, yes, they do. And the court said, no, they don't, because they are not entitled to those records under the School Student Records Act. There is a mechanism for that, and that mechanism is a court order.
Yeah. Question here, can you help define, quote, support time within an IEP? I've traditionally seen support time as a way to support students' disability with both special education services and general ed material. For example, a student has a disability in reading but needs a science test read aloud in the special ed room during, quote, support time. I don't know what the word support time means, and therefore I would never use it. I think support time is not a term I would use in the IEP. I would say, is it special education instruction? Or is that an accommodation? right? And I think we have to use those terms because the word support doesn't exist in the IDEA, doesn't exist in the regs. So support time isn't defined. And so the problem I see here is that we need to define support within the IEP. Is that instruction from the special ed teacher? Or is that the accommodation? Like the example here, having a science test read aloud in the special ed room. Well, one, that sounds like an accommodation to me. So that shouldn't be part of the student's quote support time minutes on the IEP. That should just be an accommodation. But I don't like the accommodation at all in most situations because it should be that's violating the very principle of least restrictive environment. It should be the gen ed science teacher who is reading that test aloud. A student shouldn't need to be excluded from their gen ed peers and go to the special ed room to have their science test read aloud. We are wasting the resources of our highly trained and hard to find special ed teachers by having them do things like accommodations that are the general ed teacher's job. And the general ed teacher needs to get off their butt and read the test aloud. And if they refuse to do it, they can be found personally liable, and courts have held as much. And that's what I think about that.
Tell us how you really feel, Brandon.
I got an amen. I got an amen. All right. So we've got one more question in the Q&A, but we got 10 minutes left if you guys have other questions or other things people want. Question here is, what if a young elementary student has been referred for special ed, and at that time it's discovered the student has been suspended for 16 days? Can we review SB 100? Many students are still being suspended under zero tolerance.
There are so many things here.
I know, it's really hard. So I'll start, right? I mean, with the special ed piece, and then if one of you want to jump in on the SB 100 piece, but you know, the issue, of course, if those 16 days are prior to the referral or prior to when we may be deemed to have knowledge a student has a disability, then we don't necessarily have a special ed issue or an MDR issue at that point because it's prior to the student being in the pipeline. So I think that is certainly a concern. Now, if those 16 days are while the student's in the pipeline, then we know they're entitled to the procedural safeguards, and that is a concern. But I think I certainly share the other concern here, is that I think that we've gotten too far afield on SB 100, and that we are suspending students from school, out of school, in situations that don't meet those thresholds where we're not a threat to safety or their continuing presence is not disruptive. And I think that's troublesome. And we know that the law says we are not permitted to have a zero tolerance policy except for weapons. And I still literally see administrators writing in the rationale and suspension form, zero tolerance for bullying or zero tolerance for drugs. And by using the term zero tolerance, you are cooking your own goose because the statute would prohibit us from having a zero tolerance policy. I'm looking at that on a case-by-case basis. So I'm interested what the rest of you have thoughts on basically that broader suspension issue.
Well, I'll jump in because I don't see anybody else doing so, and I've got lots to say on this one. So first of all, 16 days, setting aside the cumulative issue for special ed, anything over 10 days consecutive is an expulsion as a matter of law. And I've seen this a whole bunch recently that surprised me because this isn't new. You can only suspend for 10 days. And if you get to day 11, the problem is that not that we've just, I had somebody say to me, oh, but it's just an extra day. What are they going to do for the extra day? Well, the problem is that due process for 10 days is review. It's after the fact. Due process for 11 days is before the removal. That means you've expelled the kid without the requisite due process. And I think that prohibits an expulsion after the fact because the due process didn't happen before the fact. So the first thing is we need to be very careful that we're staying within our 10 days and actually getting that hearing off within those 10 days. unless we've got written agreement with the parents that they want to stall that time and hold the kid out. Remember, after 10 days, that kid's going back to the school, regardless of whether we plan to expel. The second thing that I think is really important is I've got a whole bunch of these suspension and expulsion forms where the rationale is because other kids might think it's okay to do this. And that sounds dangerously like the language of zero tolerance. That sounds dangerously close to that same language. That is not a rationale by itself. It may be part of your rationale, but it's not the totality of the rationale. One of the things I've heard a lot of administrators say is, well, but we always do that for this type of offense. Again, that is zero tolerance by a different name. You are citing the language of zero tolerance without using the term. So what I want to see us doing is looking at the whole child, looking at the totality of the offense. One of the questions I always ask is, talk to me about the kid. What's the kid had before? And what I always get is, well, we can't use that for purposes of proving this offense. Well, that's true, but it is still relevant as to why we're getting rid of this child from the regular educational environment. And one thing I want us to remember is the standard is that child is presumed to be entitled to their regular educational environment. So if we're going to say the child has to be removed, I don't want to hear about the one offense. I want to hear about why that one offense signals an escalation of some sort, such that we're likely to see continuing presence. We're likely to see that it's going to happen again if we don't remove the child. That's an incredibly high standard. It should be very, very, very rare that we're removing kids from the regular educational environment. Just because the kid, and I'm going to use an extreme example, just because the kid brought a gun onto school property in his truck bed does not necessarily mean that it's going to be the exact same as the kid who brings a loaded rifle into school and threatens to mow the school down or actually does so. Those are two different kids and they're two different fact patterns. I'm not suggesting one or the other should or should not be expelled. I am saying I need to understand why you're making that determination, and I need to understand an awful lot more about the child's history that to suggest the likelihood that the student's continuing presence will result in a threat to safety or a substantial disruption to the regular education.
And David, I think two things about that. One, I think your example is, where I see that more often is where it's drug offenses, right? Because I think, weapons offenses, I sometimes think about a little differently because it's easier to get to that standard. But I think it's the drugs is the one where I see people too frequently going way afield on SB 100. And I think that's there. I think the other sort of practical piece that I think is a part of this, and maybe a lesson for, the six of us here, which is we have an awful lot of administration principals who weren't principals when SB 100 went into effect. And so I think that we all did a lot of training on SB 100 5-6 years ago. And a lot of our building administrators weren't administrators then. And I think that might be something we need to follow up on with our clients, and that you all need to follow up with your building administrators to make sure everybody understands what SB 100 really did want to do.
And if I can add 2 quick points here. I know we're hammering this home, but one of the things that I hear quite a bit when we're discussing expulsions is, well, we take these offenses seriously and therefore we're going to enact the maximum that our code of conduct allows us to do. To me, that sounds a lot like zero tolerance. And when we're looking at these individualized considerations, I don't want to necessarily hear, we take all these offenses seriously, so it's the 2 years. And number 2, and this adds on to David's point about, up to 10 days is a suspension and then it's an expulsion. Just as a reminder, SB 100 does have very specific standards related to suspension and a different standard entirely for expulsion. So when you're looking at an out of school suspension that's longer than 3 days, you have to prove that the student would pose a threat to the safety of other students, staff, or members of the school community, or substantially disrupt or interfere with the operation of the school. Whereas with expulsion, You're looking at additional factors of whether removing the child is in the best interest of the school, the rationale for the specific duration of the recommended expulsion, which we've just talked about, whether interventions were exhausted, and then what David was just talking about, the continuing presence. And so one of the things I'm a bit concerned about with the question when we're talking about 16 days, I'm a bit concerned about whether we're skirting around the higher standard of expulsion to try and meet the lower standard of suspension within SB 100.
Yeah, and I think one of the things that you pointed out, Christine, is exactly right, is I often get asked the question, what's the longest I can suspend the student for this offense, when the statute says we must take efforts to minimize the length of suspension. So the question should actually be, what's the least amount of time that we need to remove the student to keep the school environment safe? And that's the way we have to ask that question when it comes to suspension. A related question here, we just got a minute left, and we do have a hard stop here at 11:30. A regular ed student who comes to school under influence, can we suspend for that? Well, the answer is, you can remove from school, suspend for the amount of time that student is a threat to safety or a disruption. So while they're under the influence, probably that's true. But the next day, are they still a threat to safety or a disruption? And you've got to look at those factors in doing so. Back to my rant earlier, if the IEP states an accommodation of a test taken in a separate location, may that test be taken from the special ed classroom? Possibly, but then it needs to define that in the IEP. And why does it have to be special ed? Right? If they just need a distraction-free environment, why does that have to be a special ed environment? That's an LRE consideration for me. And I don't want the alternate location to always or automatically be the special ed environment. Last question, and then we'll have our final thoughts here. When we need to offer a meeting to a parent for a restraint, what document do we use? A formal IEP meeting notice or an email to the parent? Well, it's supposed to not be an IEP meeting, so it won't be an IEP meeting notice for those 2-day meetings. I think an email is sufficient. Eventually, that's saying you have the right to a meeting. If they request it, then we would schedule it, but I don't think that's an IEP meeting. I'm hoping that it'll eventually just be on the ISB form that the parent is getting within that time frame anyway, but it's not yet on the ISB form. Well, thanks for hanging out with us today. I'll let David or Christine or Anna or Ellen, if you guys have any final thoughts, but I just want to say this. I know right now the job of a school administrator is as difficult as anything. I saw yesterday there was controversy where the head of the NCAA said being a university president is the hardest job in the country right now. And I wanted to say, no, I think I'm going to give that job to K-12 administrators. I think college presidents are pretty insulated. I don't know if their jobs are that hard, but that's just me. I would.
They're both very, very tough jobs at the
particularly,
moment.
what they're
Being in
giving.
education anywhere at this point is tremendously difficult.
And so I'm hoping what we gave you today are some things to help make your job easier, not harder. I know we can't always tell you what you want to hear, but we do appreciate you all hanging out with us today.
Thanks very much, everyone. Appreciate your time this morning.
Thanks, everybody.